Hello everyone. As I told you, I'm going to have Kevin. Kevin is here, my friend. He agreed to help us basically answering all these questions that you guys asked me. So I really appreciate you guys giving me this opportunity to ask Kevin these questions and get you the answers. So Kevin, first of all, thank you very much for your time. I know you're busy, but I really appreciate you helping me and my friends a lot.
Okay, my pleasure.
So we're going to be talking about wills. Excuse me. About wills, and you do work with wills and help people write them down. First question: when there is a will, when people have a will, do they have to go and register it somewhere?
No. A will is not registered or recorded until somebody dies.
Okay. When somebody dies, where do they go to record it and register it?
Well, the primary mechanism would be to open a probate case.
Okay.
That is done in the court system in the county where the dead person, the decedent, lived.
Mm-hmm.
So, for example, if you lived in Sumner County, you'd file a probate case in Chancery Court in Gallatin, the courthouse on the square in Gallatin. Wilson County, you do it in Lebanon.
Okay.
Nashville, you do it. Nashville and Davidson County, you do it downtown Nashville, the big courthouse on the square, and so on and so forth.
Okay.
And as that part of that process, the will would in essence be recorded.
Okay. How much time do they have after the death? How much time do they have to act?
Well, that's an interesting question. Actually, it's an indefinite amount of time.
Indefinite?
Yeah. Mm-hmm. You could actually theoretically open a probate decades after someone died.
Okay.
Mm-hmm.
Interesting.
So I guess as a practical matter, you wouldn't want to let too much grass grow under your feet, but most people open probate in 6 months, 4 to 6 months to a year. Sometimes it's longer than that.
Okay.
But it's not like you've got to run down to the courthouse the next day.
Okay. Next question. When people are writing a will for their kids in other country, let's say in Russia or Ukraine, Moldova, what would be the process if they die anytime? What would be the process that family would have to take?
All right. Well, so if someone dies and we have to probate a will, we have to have someone in Tennessee to act as the executor of that will. There has to be an executor is somebody who gathers the assets of a dead person and then distributes them out under court supervision. And that person has to be a resident of the state of Tennessee. We can have a co-executor from Moldova or Ukraine or whatever, different countries, but we have to have a Tennessee resident acting as an executor. It does not have to be a family member. It could be a trusted friend, but note that it does have to be trusted.
Okay. Can it be an attorney?
Generally speaking, yes, it can be. Attorneys don't very often take on that role, but it can be. Yeah.
Okay. If there is no will from husband, wife, when he or she dies, what to do and what happens?
All right. So most people, their major asset is the house. Mm-hmm. Okay. And the way the house or the deed for the house is written determines what happens to the house. And this is a good time to talk about how you own a house, if that's okay.
Yeah, sure.
Remember? All right.
Sure.
So when most people, married people, buy a house, the deed says Bob and Jane, husband and wife. Okay? It may not even say husband and wife, but if they are husband and wife, what that basically means is Bob doesn't own the house, Jane doesn't own the house, the marriage owns the house. The technical term is tenancy by the entirety. So if Bob dies, automatically and without court intervention, Jane owns the house. If Jane dies, automatically and without court intervention, Bob owns the house. So the major asset is going to be determined by the deed if a husband or wife dies. And the vast majority of the time, this is what happens. Okay? As to the rest of the stuff, if you don't have a will, property descends or is distributed according to the laws of what is called intestate succession.
Okay.
Intestate means you don't have a testament, a last will and testament. Okay? And these are all ancient words. They don't work very well in the 21st century. We're stuck with them. I'm sorry. They didn't ask me, if we wanted to use these words. I could think of much better words than these, but these are the words. So, intestate succession, the laws are pretty simple. If a husband or wife dies, the remaining spouse and the children share in the estate. That's generally not a problem unless you have children who are under the age of 18. Children under the age of 18 can't legally own property, and that can just create a whole bunch of headaches. Better to have a will, folks.
Yes. And now, just to mention, we are talking about laws in Tennessee.
Yes, we are. We are talking about laws in Tennessee. We call ourselves the United States of America. We're really the 50 little United Nations of America, and Tennessee and Kentucky might as well be Belgium and France. I do not know what the laws are in Belgium, France, or Kentucky. I'm only talking about Tennessee.
Yes. Which one is better to have, a trust or a will, or both?
Well, it depends on the nature of what you're trying to do and what you own. In some cases, a trust is the right thing, and in some cases, a will is the right thing. That's a very individual determination. I can't say generally what is best. A trust in this context is primarily used to not have to go through probate. Probate is that process where we take a will and we administer the assets through the court, or the distribution of the assets through the court. With a trust, you don't have to go to court. Is the basic upshot. You want to think of a will like a bowl. You can think of it like a bowl. That's really what it is, this kind of trust. And we put assets in the bowl. We put the house, the cars, the bank accounts, insurance accounts, whatever, in the bowl. The trustee holds the bowl. Let's say that this is my trust and I'm the trustee. When I die, let's say Victor is my successor trustee. The instant I die, my last heartbeat, Victor grabs the bowl, I let go of the bowl, boom. He is in the position to handle everything. There's no court involved. Okay? That's the primary purpose of a trust of the kind we're talking about. There's lots of different kinds of trusts, and they can do lots of different kinds of things, but the vast majority of trusts are simply probate avoidance. Okay? The trust also gives you the ability to distribute assets more slowly and in different ways than you can with the will. The will is kind of one and done.
Yeah.
A trust can go on for, I think the law in Tennessee is now 325 years. Don't hold a gun to my head. But a super, super long time. Okay? The Ford family, as in Ford Motor Company, has a trust that's been around for decades, and it's still distributing money this way to this day. You might use it, for example, if you had somebody who wasn't good with money or who had medical problems and special needs. It's a very individual determination. I just can't say, yep, everybody should have a trust, or yep, everybody should have a will. It varies from person to person, who their beneficiaries are, what kinds of properties they have, what they want to do. There you go.
So basically individual situations.
Individual situations, yep.
Okay. Is there a tax for accepting any property in a will? And is there a tax when people willing me something? Do I have to pay tax?
No. If it's a very, very large estate, and the estate has to pay estate taxes. There are no estate taxes in Tennessee anymore. They went away January the 1st, 2016. The federal exemption is currently $11.5 million, give or take, per person. And $23 million, give or take, per married couple. And the vast majority of estates are therefore not subject to estate tax. It's not anything the normal middle class person needs to worry about.
Okay. What are other ways to transfer home tax-free?
Well, there's lots of different ways to do it other than a will or a trust, but understand that anything that you do could have unintended consequences. There are risks involved in any transaction. The lecture that I give to just about anybody who walks through the door here is I say, this building has 3 entrances. 2 have stairs, 1 has an elevator. If you take the stairs, you have a certain set of risks. You could trip and fall, you could wear out your joints, you could overexert yourself and have a heart attack. So if you go, man, I don't like those risks, I want to take the elevator instead. Well, the elevator has risks too. It could get stuck between floors, it could catch on fire and burn you up, the cable could break and it could fall in the basement and crush you to death. Now, we actually don't have a basement and don't have a cable, and that can't happen, but the point is, no matter what we do, there's always going to be risks. And we have to decide what kinds of risks we're most willing to accept. It's effectively a business decision. So, for example, if you want to make sure your kids get your house, and you don't want to use a will, and you don't want to use a trust, you can gift the house to them now. Okay?
Okay.
So, what kinds of risks do that have? Well, it's at that point it's your kid's house. The kid gets in financial trouble, you lose your house. If the kid gets pissed off at you and kicks you out of the house, the kid can kick you out of the house. We can put something in the deed that says you can stay in the house, of course. If you are concerned about nursing home expenses, that potentially could make you ineligible for nursing home benefits. There's lots of different things that can go sideways. Does it work for some people? Sure. Does it not work well for other people? Yep. Once again, it's a very individual thing. We generally do, however, shy away from just giving the house to your kids. It can produce a lot of bad results.
Okay. So again, this situation would be as well individual.
Very much individual. Yeah. Very much individual. And also, not only individual circumstances, it's the risks that people are willing to take. Do they want to take the stairs or the elevator? We're going to be having risks no matter what. What risks would you rather have?
Okay. Is adding a joint owner a better idea instead of making a will?
It can be, and it cannot be. Just like I said, let's say you add a joint owner. Let's say that it's my property, you're my son, and I say, Victor, I'm going to give you half my property. And then, Victor, you run up $50,000 on your Sears card, and Sears comes after us both. Well, Sears might be able to get your part of the house and kick me out of my part. Sears isn't going to keep my money, but I could lose my house as a house through what's called a partition sale or enforcement of a judgment. So there are risks.
I have another question. If, let's say, somebody owns a house, has debt, and they die, they have a house in the will to their family.
Mm-hmm.
Can they get part of the house?
Can the creditors get part of the house? Yes, they can. Although the law in Tennessee is a little bit strange on that. There is a statute of limitations. That is a amount of time that you got to do something legally.
Okay.
For enforcement of debts against an estate. And it's basically 1 year. So one technique that may be usable in certain circumstances to avoid debt is to not transfer the house or whatever else for a year. Creditors, unless there is a very large creditor who is owed a lot of money individually, are unlikely to try and do what's necessary to get money out of an estate, just as a practical matter.
Okay.
If you owe $50,000, to Sears card, they might come after you. $5,000, they're probably not going to bother. So you can wait a year to avoid let the statute of limitations run out.
Okay, and
Now-
then transfer.
And then transfer. Now, the exception there is a mortgage. Someone dies, you're going to have to pay that mortgage till you sell the house. Otherwise, they'll foreclose.
Or
and-
refinance, basically.
Or refinance. Or they'll foreclose, and the year doesn't affect a mortgage.
Okay.
A mortgage can be foreclosed on at any time after death.
Okay.
So you got to pay your mortgage, okay?
Will adding a joint owner affect a mortgage? The mortgage company has to be notified.
Okay. So let's say you bought the house by yourself, you got a mortgage by yourself, and then you want to put your wife on the deed or something like that,
Or son.
or son or whatever. You know, obviously you need to make sure that you've thought through the risks involved in that kind of transaction very carefully. But what you're concerned about in that question is, can the mortgage company fly in and go, oh no, this doesn't work? In all mortgages, and actually in Tennessee we use what are called deeds of trust the vast majority of the time. They have what is called a due on sale clause. Okay, that means that if the house is sold or transferred, the mortgage company gets its money back. Okay? I have personally never once seen that enforced. Okay? I work with a young lawyer who has seen it enforced one time in Indiana, where he's from and where he's also licensed, smart young fella. But that's the only time he's ever seen it. And so we generally do not consider it to be a risk.
Okay.
But it technically can happen.
So if
Because
I
what the mortgage company cares about is getting their money.
Yeah.
You know? So if they're getting their money, they don't care.
Okay.
And if they're not getting their money, they're probably not going to go to a due on sale clause. They're going to do a foreclosure. You know?
So as long as the mortgage is getting paid, usually
You're probably going to be
it's not a
okay.
problem. Okay.
I have never seen it be a problem. I've heard of it being a problem one time.
Yes. Another question: if the receiving of the will person is a citizen of another country, will he or she pay the taxes for what he/she receives in U.S.?
Well, there are no, as a practical matter, as we said earlier, there are no U.S. estate taxes
In Tennessee.
in Tennessee
Yeah.
and federally, because of the huge current federal exemption. You know,
Okay.
you got to be super rich in Tennessee to ever have to pay estate tax. Super duper rich. I can't speak to the laws of the foreign country.
Yeah.
You know, it depends. I don't know. You know, does Belarus have an estate tax? It beats me.
Yeah. Yeah.
Probably beats you too.
Yes,
You know.
yes.
You know, that's you'd have to talk to a lawyer in the place where you live
Yeah.
to find out if you're going to incur an estate tax.
So
I
US
frankly doubt it. In most legal systems, the estate pays the estate tax based on where the property, where the decedent, the dead person, lived, or where the property is located, or both. Rarely is it based on where the recipient lived, but you know, I can't begin to know
Yeah.
what the law is in the Ukraine or Russia or Singapore or the Philippines or Hong Kong or whatever.
Yeah.
Well, Hong Kong, being a former British colony, would probably that's a safer bet because they follow what's called English common law, like America does.
Yeah.
Or at least they used to.
How to transfer a property into a living trust? Is it easy enough to do it, or to do it myself, or we need to hire a professional?
Oh, if you're going to set up a trust, for Pete's sake, don't do it by yourself, okay? But the process, the lawyer creates what's called a trust agreement. The trust agreement creates the trust bowl, and it names a trustee and does other things. And then you deed the property into the trust. It's not that complicated.
For a lawyer.
For a lawyer, yeah. But
Okay.
you know, as far as trying to write the trust agreement to create this bowl, if you don't know what you're doing and know Tennessee law, you could make a real big mess,
Okay.
and a very expensive mess to fix.
Okay. If there is no will, the owner has done a POA, a power of attorney, in U.S. and passed away. his power of attorney is still valid after death.
No, POA stop working, powers of attorney stop working at the moment of death.
Okay.
At that point, we either have a will, a trust, and if we don't have either of those, we have the law of intestate succession.
Can a person with power of attorney create a will
No.
for somebody else?
No,
It has
but
to
they
be-
can create it. They may be able to create
Oh, not
a
will.
trust.
Trust.
May be able to. Yes, it depends.
Depending on the power of attorney.
Depend on the particular power of attorney.
Okay.
But I have done that before. I've created trusts using powers of attorney.
Okay.
Ideally, folks, we do this enough in advance so we don't have to, we do it while
Yeah.
people have all their faculties and they're in good health. We do some good planning. In America, it's sometimes called getting your ducks in a row. If you want to be a little bit more morbid about it, it's called getting your affairs in order. You've seen these old movies and the doctor comes in and says, well, I've got some bad news for you. You better get your affairs in order. That's what we're talking about here. This is part of getting your affairs in order.
Okay. Is a will valid if it was written but the person did not notarize it?
So, having an effective and valid will is complicated. If you don't go to a lawyer, and I strongly recommend that you do, because it is so complicated, if you want to write your own will, what I recommend is do it entirely in your own handwriting and sign and date it. Okay? A notarized document not written entirely in your own handwriting and signed and date may or may not work. It just depends on some of the magic lawyer words that are in what you write down. And if you're not a lawyer, you're not going to know the magic lawyer words. And I don't necessarily like that state of affairs, but it's what we are stuck with.
Okay. Is a will done on the app? As you know, many of them they are.
Yeah.
Is it as good as other wills done by an attorney? Are they valid?
Well, the will done by an app or LegalZoom or Susie Ormond's Will Kit will, they can be valid or they may not be valid. And they may be work the way you want them to or they may not work the way you want them to. Here's a little story. I have a client, just recently finished up the estate as a matter of fact. The decedent, the dead person, made up their will using a Susie Ormond Will Kit will. And there was a problem. There was a blank page. Did that render the will invalid? Well, I went down to Davidson County and probated that will and appeared before Judge Randy Kennedy. And I explained to Judge Kennedy that we had a Susie Ormond Will Kit will. And he wasn't mad at me per se, but he did yell at me because of what was going on. And he said, I would rather take my 81-year-old mother down to the local car mechanic to get a will than use a Susie Ormond Will Kit will. She'd probably get a better result from the car mechanic. And there you go. I would never, ever, ever recommend a Susie Ormond Will Kit will or a app will. LegalZoom, supposedly has Tennessee licensed attorneys reviewing their stuff. It's better than nothing. But what a lawyer does is ask you questions and have you consider scenarios that you may not have thought of. Let me give you an example. I had some folks in here, they just did their will, just executed their will. I think it was on Monday. Today is Wednesday. I think they did it on Monday. 2 people married a long time, 1 kid. They want to leave everything to the kid. So I said, well, what happens if the kid dies before you do? Well, I never thought of that, they said. I said, well, you got to figure out who's going to get your stuff if that happens. It does happen. It's not likely, but it is very possible.
Yeah. So you basically, if people would come to you to write a will, you basically would foresee all kind of scenario different and ask them questions, get them ready. So when there is something if people write in the will and it's not saying for the special situation that might happen, the will would be ready. Basically,
Yeah.
you would help them to
Try
get ready.
try and figure out bad things that might happen.
Okay. When people are married, but only one is on the title on the deed, what do they have to do? What would be the steps to fix it?
Well, earlier in this video, I talked about a tenancy by the entirety, where the husband doesn't own the house, the wife doesn't own the house, the marriage owns the house, okay? And if you got a situation where the wife or the husband isn't on the deed, or maybe the wife and husband weren't married at the time that they got the property, they're both on the deed, but they weren't married, this doesn't happen. And all we have to do is retitle the property, prepare a new deed that fixes that.
Okay.
It's not that complicated.
It's not that complicated. Would you be able to help in this kind of
Sure,
situation?
we do that sort of thing all the time.
Okay. As we did some closings together, and you mentioned that in Tennessee it is obligated to have husband and wife sign the deed, be same together on the deed, right? Or did I get it right?
Well, I think
When they buy a property, like if there is married couple and they buy a house, can husband or wife buy on their own and have just the house to their name, or it's going to have to be?
Well, no, a lot of it has to do with what a lender will accept. Okay? And, the lender sometimes says, yes, the husband can be the only borrower and the husband can be the only person on the deed, but we want both the wife and the husband to sign the deed of trust, which is what a mortgage is in Tennessee.
Okay.
Most of the time, the lender wants the wife to sign because a residence is marital property, or is probably marital property. And that means the wife has rights in it, whether she's on the deed or not.
Okay.
And so they want to put the wife, in essence, on the hook, or have, not entirely, on the hook's not right, but have the wife give her or husband's lender, give her husband's lender the right to foreclose, basically.
Mhm. If there is no mortgage, just cash.
You can just have what's called sole and separate property, but that doesn't necessarily mean that it won't be marital property. If you're like having trouble with your spouse and you're trying to avoid letting your spouse have a piece of that property, that's an uphill battle.
Okay.
There are ways that can potentially work and many that don't.
Okay. In a case of divorce, if they are both not on the title, in case of divorce, is it enforceable for him or her to get the half of the property?
Get some back, yes, because
It doesn't matter if she or he was on title or not.
It probably doesn't matter. There are circumstances where it could,
Okay.
but marriage is viewed by most states as a legal and economic partnership. Okay? And basically everything that comes into the marriage is owned by the marriage. And when the marriage ends, they have to split out stuff that came into the marriage. All right? The primary separate kind of property would be an inheritance.
Mm-hmm.
Like your mother dies, she leaves you money, you keep it separate from your spouse's money, and you might be able to say that's not marital property.
Oh.
Okay?
Only if I keep it somewhere separate.
Only if you keep it separate.
Okay.
But let's say your mother dies and she leaves you $100,000, and you take that $100,000 out and you add a bedroom onto your house. Well, guess what? You've turned that separate property into marital property, probably.
Yeah.
It depends on the circumstances and a bunch of other things. There's, every situation is different.
Okay. Awesome. Thank you very much, Kevin.
My
that was
pleasure.
good answers, good information. If you guys have any more questions, you text me, write me, comment on my videos. Kevin is going to be tagged on the video as well. We're gonna have his phone number as well, and his information. If you guys need his help anytime, he's a great lawyer, great guy that helps me a lot and all my clients. So Kevin, I appreciate it very much.
Thank you, Victor.
Thank you very much.
Appreciate it.
Thank you.